Good morning, everyone. So we have an important topic today for Audit Tuesday, the legal ramifications of improper identity governance, legally termed lack of due care or negligence. So to help explore this topic, we have cyber defense attorney Shawn Tuma, defense and GRC expert Stacey Cameron, and cyber expert Justin McCorkle. So hi, everyone. How are you?
Hi, Ashley.
Howdy.
Hi. Perfect. Let's get started. So, Shawn, let's start with you. Can you please introduce yourself to the Audit Tuesday audience? So, you've been doing cyber defense law since 1998, right?
Yes. So in 1998, I got into what then was tech cyber law while I was in my second year of law school, and got into it with Y2K and all of the Y2K litigation that was supposed to be my rocket ship to stardom and early retirement. But as you see, I'm still here, so it didn't work out quite so well. But my career has evolved quite a bit over the years, and got into hacking law in the 2000s, and data breach and incident response, and cybersecurity, all that kind of stuff. So I'm with the law firm Spencer Fane. We're a U.S.-based law firm. I'm co-chair of the cybersecurity data privacy practice, and our office in Texas, in our Plano, Texas office. Dallas is our suburb. So,
And and Justin, so you also have a unique background and premise to your company, Crucial Cyber. So can you give the audience some of your background?
Sure. I approach cyber from a business first perspective. And it's a little different way of thinking about it than coming at it from a cyber first or whatever. We're thinking about this from a business problem issue. And basically, my background as it relates to cyber is related to cyber startups and private equity. I've consulted with business owners and executives to try and determine what's possible to accomplish from a business objectives mindset. Cyber, you think about it, it can be this black hole. You can just spend all of your money and resources and everything else on cybersecurity. And even then, you don't know that you're going to be 100% secure. And so that's just not tenable from an investor perspective. So we look at it from a practical perspective. We ask questions like, how do we protect ourselves from lawsuits and fines as it relates to a breach? How do we set reasonable, clear goals for our cyber program? And usually we're working alongside cyber attorneys to provide the project talent and find answers to questions for each individual client. So I'm really glad Shawn's still around because I get a lot of wisdom from him, and he's exactly the kind of person that I like to work alongside.
works both ways, Justin.
And Stacey, so since you have so much experience in both GRC, especially at the federal level, can you give the audience your background?
Yes. So my background is I've worked as a federal employee. I worked as a federal contractor, as a federal civilian employee supporting federal law enforcement. So I was able to support Department of Defense. I've worked on the commercial side currently. I wear multiple hats. So I have my own company called SideCam Strategies, as well as I'm VP of Strategic Services at Direct Defense. That works a lot of cybersecurity areas. So I'm really loving being on the call with the attorney and cyber business practitioners. And then I'm coming in from a cybersecurity compliance and regulatory practitioner area. So I've worked with joint task force efforts, U.S. laws, whether they're U.S. privacy laws or cyber laws, international laws. A lot of the clients and everyone that I work with, or even different agencies, when you're working in different countries, you have to understand those regulations. All of them have privacy requirements, so you really want to understand that aspect as well. And all of them have cybersecurity requirements as well. So even as Justin was talking about, there are business components, and you can't really separate the two. So please don't try. But I do know, as a practitioner, when to call in the lawyers, when to call in the business practitioners, because we all should work together. We all have the same end goal, but just really being in so many different areas, whether it was healthcare, financial, working with startups. Working with startups is a lot of fun. because a lot of time the resources are really dedicated on engineering and operations. So really understanding the other sides that go into that's being required more and more, right, as you start seeing breaches and what have you. So I've been able to just experience a lot of different aspects, and yes, heavily on the federal side. So being able to put out the requirements to our contractors for what we wanted, and then on the other end being the contractor fulfilling the government's requirements.
So, Justin, one of the things you say often is that business owners approach cyber differently than cyber practitioners. So, what do you mean by that?
I mean that cyber isn't a core business function for very many businesses. Cyber is risk mitigation. That's how a business leader looks at cyber most of the time. They want risk reduction as easily and as cheaply as possible. You think about it from everybody's self-interest. The cyber industry sees financial opportunity in cybersecurity. Cyber practitioners see risk everywhere. And that's not how business leaders are looking at it. They just want it to go away. It can never go away 100%, though. Even if you spend 100% of your revenue on cyber, the risk is never really going to completely disappear. That's why I try to find achievable goals to help the client win. We want to be able to look at this and say, what can we actually achieve, and know that we've actually accomplished some objectives and move forward instead of just constantly shoveling that money down into the black hole of cyber.
Shawn, let's have you start this off. So, why exactly do companies call you for defending cyber defense? It's after they get hacked, right?
Well, many times. So the bulk of my work is either incident response, so serving as a breach quarterback, if you will, or coach, or whatever else you call it these days, guiding the company through the incident investigation, response, remediation process, working in sort of a project management type of role, but overseeing and using the benefit of the many incidents I've been involved in, just bringing that perspective. The other aspect is proactive risk management that we help with, taking the real life lessons we learn through the incidents we handle and applying those. When we see repetition, we see the same things over and over. And so when you start seeing that over and over, it's helpful to be able to bring that to the clients and say, look, we've seen a lot of companies in your position. They're doing a lot of these same things, and they're leading to real world incidents. Let us help you go and find the solutions. And a lot of times, that's leading right into bringing in true experts on the technical side, like Stacy and Justin, of saying, hey, I'm not here trying to be a CISO. I'm not here trying to do the technical work. I'm identifying, spotting the issues, and then leading to figuring out the right experts to bring in to help solve that. And it's very much a team activity. But So what we're trying to do is understand the issues proactively, from a risk management standpoint and a legal standpoint and a regulatory standpoint. And then when we come in on the back end, either in an incident response, we're trying to best position the client so that they're in the most defensible position possible when the litigation comes or the investigations come, either from the plaintiff's lawyers who are filing these lawsuits left and right now, or the regulatory agencies at the state and federal level that are opening investigations and then ultimately bringing claims if they're not satisfied. So it's all tied in together. We're all part of the same team, as Stacy said, each just having a little bit of a different role.
And Shawn, so when enterprises get breached, the parties that are suing are trying to prove that the entity holding the data was negligent, right?
Yes. Yeah, that's the foundation of the allegations at its core. Now, they may doctor it up and say, failure to comply with contractual obligations, which in Stacy's world, all the government contracts and the flow down provisions through the third-party risk management process. So that negligence can be a breach of contract, right? or you're failing to comply with statutory requirements like, the HIPAA security rule and many of the obligations there, or, various states. NYDFS has a very prescriptive legal standards you must adhere to. And so what they're ultimately claiming is negligence because you failed to use due care in protecting the network, which in essence means you failed to protect the data, which is what people really care about in that sense. And so they claim negligence, they doctor it up, and then sometimes it is negligence from anybody's perspective. In a lot of cases, they really were doing all they reasonably could have, but they're still going to claim negligence no matter what.
And Stacy, for your GRC practice, for both government sectors, you're trying to put controls in place to both secure the enterprise and provide a legal defense if they are breached, right?
Yeah, so it's funny, right? I feel like I should always say this. I am not a lawyer, nor do I play one on people. Why Shawn is on this call, but yeah. So in all seriousness, as a security provider, absolutely these things come into mind. Not just from understanding it from a legal perspective, but seeing it happen with others, right? Through experiences, understanding the laws, helping folks with compliance, seeing people get sued. So just really understanding that these things are realistic and they can happen, right? So a lot of compliance, especially when you're around privacy, these are all put forth by laws, right? So whether you're looking at GDPR, whether you're looking at your CCPAs with California Privacy Act, or if you're looking even Shawn just mentioned NYDFS, or you're looking at FERC or any type of or GLBA or any of these other different standards that you're looking at them. A lot of them are from a privacy standpoint are driven by laws. So I always, as a practitioner, and heavily encourage and insist that my clients bring in their legal representations, their general counsels in on these discussions, right? Because at the end, those are the ones that are going to accept liability. I cannot, nor do I pretend to accept liability on behalf of any organization, agency, or what have you. But there is a level of those that can, and I can express my opinions, my advice, just based on how I've been working in industry. But these things that we have to think of, right? So when we're looking at, we're not just doing our due diligence and our due care because we want to make sure that we're keeping data safe, but there are laws that we have to adhere to, and we have to demonstrate that we're doing things and even just being good stewards of people's data or what have you. If you think about it, in the U.S., and this is a question that I'll probably have for us later, but in the U.S., there was no one central federalized law saying this is what we do, right? So from a privacy standpoint, so there's a lot of different laws that have different aspects of privacy with it, but the states are making a lot of laws at the state level. So those types of things. And one of the questions that we can table for later would be what Shawn's thoughts are as far as where the laws may change on a federal level. But those types of things, I'm always going in and understanding, are you able to, did you put the right security controls in place? Not just put them in place. Did you do your diligence and do your risk management strategies and making sure you don't want to overspend, but you don't want to underspend as well. So you want to make sure that you're doing what you're capable of doing, because yes, there are restraints on the financial side, but there still is the necessary due care that has to be taken and be done and put in place. So you got to manage it. You got to apply your security controls. You have to manage them. You have to monitor them. You have to augment and correct them. So, and then you also have to do it from a compliance and regulatory and legal standpoints.
So speaking of due care, so Justin, isn't the flip side of negligence due care? And isn't that what enterprises should be practicing, due care on their IT systems?
Sure, but there are general and specific answers about how to do that. It's not a one-size-fits-all type of thing. But anytime a business leader or an executive team is looking at any problem, what they really should be doing is setting objectives that are definable objectives. Whenever you get away from that, you get into this situation where you don't actually know what the win is. And what we really want to do is bring a winning mindset back to cybersecurity. I think that's one thing that the cyber industry overall has really lost in the last few years. We're just kind of giving up because we've been talking about preventing breaches for all of these years. And then it turns out that even organizations that are trying their best to prevent breaches are still getting breached in these various ways. And so it just leads to this defeated mindset. Well, there's really nothing that we can do about cyber. It just kind of is what it is. That then gets into the cycle where we're not spending enough on cyber because we're saying it's impossible anyways. Then we have people like Shawn come in because something bad has happened, and now we're dealing with legal costs. And so we're back to the table of saying we need to spend more on cyber, but what's the goal? So what I want to do is to think about it from a listed goal perspective. Here are the things we actually want to accomplish with our program. And it can't be something like we want to prevent breaches. That's not definable. It's not achievable. Instead, what we have to do is to step back and to get rid of that impossible language, because it is impossible language. If you're a business leader and you're being given this impossible goal of prevent breaches, and then you suffer a breach, if you were spending all this money or whatever, the expense is ever growing otherwise. So you're waiting on this potential breach to happen that you're supposedly setting this goal to never allow to happen. And so every year your cyber programs are costing more and more revenue, and you don't know really what you're spending the money on in the end. Did you not have a breach because you spent all that money, or did you spend all that money and it was a waste and you wouldn't have been breached anyhow? So instead of thinking about it like that, and just saying, well, we did the best we could do with the arbitrary amount then in the end that we decided to spend, we approach it with the goal of due care. So that then starts changing our mindset. It changes what we're trying to actually accomplish. So we can essentially have an attorney such as Shawn provide oversight and know that we are accomplishing a baseline of here are the things that we really need to be able to do, so that if we show up in court one day, we can lay out, hey, here is what we've been doing. It's measurable. Here is the improvement that was being made. We can, so then check those boxes. Here are the things we were told we should do. Here are the things that we did. Then we mature the program over time strategically. We couple that with cyber insurance. Now we're getting to tangible wins. We're actually able to say that we're winning in cyber. And that is not necessarily directly tied to whether or not we were breached. It's tied to these things that we can actually define. It's not only more cost effective that way, but it lets us know that we're achieving something. We are making our progress in the program. And that's just what I call a winning mindset. I know that I'm doing my job now.
And Shawn, the regulations and guidelines, they're explicit about due care, right? Like HIPAA, PCI DSS, SOX, and all the other ones, right?
I mean, on a very basic level, yes, in that they prescribe that you use reasonable measures, whatever that may be, to protect the data. And some of them are very granular in providing some specific details of what should be included in your information security program or in your efforts to protect the data. We're seeing some laws that are like that. But one thing we have to understand at the outset is in the law, you can be sued for any reason or no reason whatsoever. So you can have the best cybersecurity program in the world and have an incident and still be sued. So we're not preventing getting sued, because you can be sued for anything, whether it's legitimate or not. Now, the suit may get disposed of quickly. It may get thrown out early on a motion to dismiss or summary judgment motion or something of that nature, if you can really buttress up your defenses and get out of it. But that didn't stop you from getting sued, right? So just wanted to get that out there. The next thing is, everybody is looking for a checklist of something that says, tell me what I must do to be secure. And the plaintiff's attorneys, if you read the lawsuits, they're going down this kind of amorphous checklist in their pleadings of saying, you didn't do this, you didn't do this, you didn't do this. And so the goal is to make it easy by finding, here's what I've got to do to be reasonable or to use due care. But at the end of the day, what we're trying to find is what is reasonable cybersecurity. And reasonableness, unfortunately, it's not a checklist, because the risk of every single organization is unique. The risks may be two identical businesses, but in different jurisdictions have different risks. In different types of data or employee data or whatever else can change the risk profile dramatically from very similar organizations. And so I use a saying that is, reasonable cybersecurity is a process. It's not a definition. It's engaging in the process of assessing and understanding your risk, of, what NIST would call the identity, identifying your risks and the problems. Then your execution, your strategic planning, execution, and that process. Engaging in that process is how you find reasonableness. And that's how you find what is really due care. Now, I say all of that because that's the very big picture, right? If you are failing to use unique passwords, or you are failing to use MFA, or you are failing to use a VPN on your RDP access these days, or you're failing to have immutable backups, or God, I'm seeing so many business email compromise cases right now. You're failing to have a process in place in your organization to pick up the phone and call when you get that email that says, change my account, wire $1 million here, there, somewhere else. Those are very basic steps that can be looked at and said, no, when you're not even doing these things, you're failing at due care at that most basic level. But at the end of the day, it all depends. It all depends on the facts, what jurisdiction you are in, because HIPAA, you're going to have a very specific set of controls. NYDFS is another. Massachusetts has a very specific information security program requirement that you have to have, even if you have one Massachusetts resident's data, and it is very prescriptive. So a big part of this process is understanding where your regulators are and what the laws are of those jurisdictions and environments that are going to be applicable to your organization, and then adjusting your program accordingly. So it's not easy.
And Stacy, are the enterprises you work with providing the due care specifically on the identities that they actually should be?
Oh, fun question. And I'm just sitting here and enjoying Shawn as he's talking, and he's just right in my in the risk management space, right?
I'm not only enjoying, I'm taking notes.
Hey, we're tied in,
right? And then on talking about people getting just sued for anything, reminds me of when McDonald's got sued for their coffee being too hot. So now all the cups say hot, hot, hot. So sometimes we just got to put it as a practical area. But yes, so yeah, I'm starting to see folks, do a little bit more due care around identity. It's being more prescriptive in the requirements from a regulatory standpoint. But I mean, just piggybacking off of what Shawn was talking about, and even Justin brought in the financial side of it. All of these. So you have the laws that are going to specify what needs to be done, and the legal requirements around certain things, and of course, the repercussions for not doing certain things. But then you have these frameworks that people are leveraging, right? So there's difference when you're using security controls versus if you're using like a security framework or a risk management type framework. So the frameworks add that governance piece. All the frameworks come back and they'll come with, and even some of the laws will be prescriptive. You got to do a risk analysis, you got to do a risk assessment, but it doesn't really get into the specifics around it. For instance, PCI DSS is a requirement set, and with the requirements, with the latest one coming out 4.0, they expanded on what it meant to do a risk assessment. I've gone different places, and they're going to hand me the PCI risk assessment, and it's literally a list of all their IT assets and the vulnerabilities on them. I'm like, here you go. This is my risk assessment. And, I'm looking down and looking up and looking down and looking up. And it's just like, maybe this isn't what the risk analysis should be. But a lot of the things that we're talking about, and a lot of making sure we're doing the due care and the due diligence and everything that we need to do, a lot of these standards are trying to touch on, and a lot of the laws are trying to touch on and say, hey, do these risk assessments, but reference this other item on how to actually do it. But you can really leverage the risk assessment to go in deep and really understand from a business impact. You have to understand your threat landscape. You need to understand what's the priorities important and importance within your business. So you need to look at all these aspects. You need to address the financial and the reputational risk, right? So a lot of times, especially really, really large entities, they may say, oh, we can take this fine, it's a drop in the pocket, but what does that mean for our reputation, right? Yes, we can afford the fine, we can just budget it in, but is that going to touch our reputation? Because eventually it's going to hit you in your pockets. So when you're looking at these things, including identities and making sure that you're doing your due care, yes, some of these standards are starting to be more prescriptive. Yes, people are understanding and starting to see more breaches are using whether third parties, whether, a lot of things that you want to do from a nefarious perspective is you want to escalate privilege, right? So a lot of these things you try to compromise an identity, right? That's a really great threat vector, really a really lovely place to get in and really start owning an organization. And so a lot of these things people are understanding, so they're trying to do more. Sometimes they understand, sometimes it's very manual, sometimes they don't really understand how to do it, sometimes it's limited. There's blind sides, right? So when you do that full-blown risk assessment, when you're really digging into it, and yes, there are business risks, there are technical risks, there are all types of, there are personnel risks, there are really areas that you really need to understand and get into, and that just, I think we keep touching on it. Don't just be one-sided focus. I'm just going to sit on cyber, but no, I got to understand business. I got to understand legal. I got to understand all aspects. They all come together and work together. So am I seeing it? Always areas of improvement, but definitely people are trying to hit on it a little better.
I want to add something real quick because Stacy mentioning the risk assessments. Just last night, the U.S. Department of Health and Human Services Office of Civil Rights that enforces the HIPAA laws published what is its second out of all the ransomware cases it's investigated, its second enforcement settlement against a healthcare organization for a ransomware event. And when it listed the reasons why, the very first reason it listed was failure to do regular risk assessments, because the OCR knows you can't protect against what you don't know. And if you don't understand your risk through your risk assessment, you can't have a reasonable cybersecurity program tailored to your risks because you don't know what they are. And so, Stacy, I mean, that's teeing it right up for you.
I told you, I'm just sitting here listening to you like, okay, let's go. I know Justin's over there getting antsy too.
That recognizes that there are evolving risks. As the business changes, even if everything else stayed the same, as the business changes, new risk exists, but everything else is moving as well. It's all like us. We're sitting on this planet, right? But we're all spinning while we're circling the sun, while our solar system is moving through space. It's not stable. So we have to continually come back and look at the same things over and over again so that we get a better idea of what the current reality is.
And Garret, these regulations and guidelines, they're explicit on identity practices and identity governance, right?
Yeah, there is something that should be clarified, and a lot of people confused. The guidelines, I mean, like NIST just wonderfully came out with a new guideline, the NIST CSF, which is pretty much the Bible for a lot of people and a lot of the other regulations. CSF stands for Cybersecurity Framework. 2.0 came out. And we're going to be doing tons of Audit Tuesdays on this and have that lined up. What's relevant is that's a guideline. Actually, we were at a company, I actually presented in NIST, and they put some of the ideas into some of the standards under guidelines. Okay, NIST is the good guys. They're basically look at the industry, interview the Garrets of the world with the products, they interview the customers, they look at the hacks, and they say this is best practices. That's not what goes on in the regulations. The regulations pull the guidelines and say, by the way, this is what the best practices should be, and if you don't, you can be fined. And Shawn correctly stated around HIPAA, OCR, the Office of Civil Rights goes and prosecutes prosecutes companies, especially around healthcare, because OCR is associated with the HIPAA practice, and then they start fining these companies by records breached. And then the practices, they go and look and say, okay, they do their due diligence on a company, and look and say, by the way, I mean, you don't have best practices. I mean, you instead, and this is where the SolarWinds came up, right? Because SolarWinds got hacked. Fine, as you know, Shawn says, people get hacked, and I say in my prezos, hacking's like rain. It happened yesterday. It might rain today. It's sure the hell gonna rain sometime in the future. You know, if you're in Orange County, they seed the clouds. Don't ask me why. Okay, but what I should say is what's happening in the hacking is once you're hacked, and then you have to disclose your breach, which is the new law for the SEC put out. They have the right to look at what your practices were. And the bottom line is, were you intelligently working with Justin and Stacy to come up with a adequate defense, right? What were your practices? Or in the case of SolarWinds, and look up one of our Audit Tuesdays, we dug in deep, were you just checkboxing this? Is there literally email proof that the CTO would just say, yeah, say we did that, say we did that, say we did this? Well, that's what the SEC says now is criminal, is just checkboxing what you're being reported. So the bottom line is, it's best practice, because NIST is a good group, and they're telling us, you know, this is how you use state security. And then the actual regulations are things that companies are being sued on, because you have documented, you have stated that you are doing these practices and procedures around cybersecurity, and then if you're not, as prove you're not, then you are, subject to fines and subject to lawsuits, and both the civil and the criminal now.
And Shawn, these regulations with the stipulations on due care and proper practices and procedures, they can be used against the defendants in a lawsuit, right?
Oh, yeah, absolutely. I mean, to Garrett's point, the claims, as I mentioned earlier, they're all kind of grounded in negligence, but they're phrased in other recognized claims like breach of contract. One we see a lot when it's consumer information at risk or at issue is misrepresentation or deceptive, false and misleading trade practices, for the reasons Garret said, because your advertising is doing or protecting data at a certain level, and then you're not doing it in practice. And so that falls under various deceptive, misleading trade practices laws in the states. But, I mean, there are, like when we're talking about just access management or authentication, these laws have paragraphs of specifics of what you have to do and how you have to do it. Not all of them, but some of them do. And then we have to look at NIST and understand, as Garret mentioned with the CFF, is most of the regulatory agencies are flowing down. They're either federal agencies or they're state agencies who are adopting a lot of what the federal agencies are doing. They're comfortable with NIST because that's what they're governed by. And so while it's not necessarily binding, enforceable law per se, it's absolutely looked upon as a standard of reasonableness and acceptance. And so when you're not doing those things, you can expect to see, number one, the questionnaires from the regulators going almost line by line. Or did you do this? Did you do this? Did you do this? And you've got to answer that truthfully. Okay. Then if it's an enforcement action being brought against you, you will see specific claims in those lawsuits failed to do this, failed to do this, like going line by line. And then if it's a plaintiff's lawsuit, you will see failed to follow NIST guidelines, failed to follow HIPAA guidelines. They will specifically lay all of that out in their allegations. So they absolutely are using the failure to comply with these requirements against you in those lawsuits.
And Shawn, you've been directly involved in defending clients on HIPAA lawsuits brought by the Health and Human Services Office of Civil Rights, right?
Yes. So primarily what we see are investigations that precede a lawsuit. So the lawsuit usually only comes about from the regulator if you don't reach a settlement or an agreement. More litigation is out there from class action attorneys. So it's class action litigation, but they flow in much the same way. With the regulatory HIPAA, what you'll see is Health and Human Services will send over a data request. And that's where they ask for all of your policies and procedures and training. And they're gathering this information to see how have you been doing things. Interestingly enough, going to this point, about a year and a half ago, we saw Health and Human Services in all of our active investigations send out a letter saying, tell us what recognized security practices the organization was using for the preceding 12 months and provide documented proof of that, because it was a mitigation on potential penalties if they were doing that. So what they're looking for is, if you were using all those things Garret just mentioned, show it to us and let us see it for the prior 12 months before the event, because that's going to factor into determining whether they were being reasonable or using due care. And so the only way you can defend yourself once the events happened in either the litigation or the regulatory enforcement is you have to be able to go back in time and show we were adhering to these requirements at the time this incident happened.
Stacey, I have a feeling I know the answer to this, but just for the audience, so you spend most of your time being proactive, helping your clients, right? You don't wait until it's too late and you have to go backwards.
No, I'm making Shawn all the money. No, absolutely. Absolutely. The ideal is to be proactive as possible. We've mentioned a whole lot of things. I'm not a fan of checkbox compliance. I will actually go to bat against auditors with my clients if I think it's, if it doesn't make any sense. And again, if you've done your due care, then you have the documentation to say why you stand by certain decisions that you've made, right? If you're making these risk-based decisions. I was taking notes while Shawn was talking, and a lot of things that he was talking about with NIST, it makes sense, right? So you have a research institution that's putting out these standards that's using everyone, right? They're using folks from government, they're using folks from academia, you're using business professionals. They're putting most of their standards out to the general public for comment, right? So they're doing their due care to make sure they get responses and everything on a lot of the standards that are being issued. And you start seeing things like even years ago when I was supporting the DoD, they started, as their security standards started growing, they started referencing NIST, helping with the energy sector using some of the NERC standards. Then they started referencing NIST, right? When you're looking at HIPAA is starting to reference NIST. So they're going to reference all of these. If you're going to do something when you're bringing things and you're building a case and you're trying to demonstrate that you're doing everything that you need to do, then what is your standard? Did you just sit in a room by yourself and say, I think I'm doing really well here? Or did you use a proven framework or methodology?
I like where you took that, Stacey. That's what the frameworks are for.
Clairvoyance works well.
Clairvoyance. How many times do you see that as a defense, right? But yeah, so those are the things that you really want to get into when you're not just that you're doing what you think is right, but you've actually done the research. You've Googled, you've read a memo, you've read a directive, you read a standard. You've talked with different folks, you strategized, you've done your risk assessments and everything, and you didn't just go through the motions. You do them and make them usable. And I lot to do that. Like when I'm being proactive, I'm like, hey, let's do something. What's important to your organization? If we're going to come in and do a risk assessment, let's make sure we do something that you can use, right? What are your pain points? And a lot of times it starts with, I don't know where to start. And I'm like, that is a starting point. And helping you identify where to start. And we can help you do those types of things. So yes, definitely have to be proactive about it. There are going to be chances, because when it comes down to it, like I don't do so much on the IR side now, but previously, I'll get called in on an IR to come in and help. And, some of those times, my very first one, I remember, the senior consultants going in, hey, you may get called to testify in court. I was like, I hope not. I hope I'm falling up down the chain. No one's ringing my bell to testify in court, but thank you. but those types of things that you really want to be proactive about. So you can, if you have to defend yourself, you can present the evidence when you're getting data requests that it is showing that you've done everything that you could, the best that you can, right? So there's going to be areas where if you didn't make something, well, why is that? Oh, well, I got this document, risk assess, justification on why I didn't make this, right? We wanted to, but maybe we couldn't afford it. That is a justification. If you don't have the money to it, that is a justification. It is considered and it is taken into account. So now if it's just poor planning, then that's something else, right? So even the federal government, they have requirements from a federal standpoint that you have to allocate funds and sufficient funds based on your own internal knowledge for security. And making sure, and you have to report all of that information up through Congress. So these types of things can be used against you in the court of law.
Against you or for you?
Or for you, thank you. Or for you.
Like that.
It's like grade school math. You got to show your work.
Show your work like that.
Perfect. Okay, so we have a few questions from the audience. So Justin, question for you. Can you expand on the difference between risk and security as far as the different mindset and practices?
Sure. To kind of think about it really simply, security is about doing things right, whereas risk is about doing the right things. So it is kind of what was just being touched on by Stacy a moment ago. If we do, for instance, a risk assessment, we're trying to figure out what the risks actually are, so that then we can turn and do things right to try to limit those risks, reduce them in the ways that we can. So if you want to know what your risks are, you have to think holistically. As Stacy mentioned, there's all types of risks that we're trying to evaluate and identify what they are. When you think about security, you think about all the different pieces that go into a good security program, whether that's encryption and making sure that's being managed correctly, enforcing your MFA, or for instance, what Garret is doing, looking and making sure that we're removing user profiles that should no longer be there on the network. Maybe we are also putting in place some security provider that is looking for active threats in the network, doing that type of work. All of those things are part of a good security program. But the risk assessment is to try to figure out what we should even be looking at to begin with, because a lot of times those risks are just not present. We don't, that is to say, we don't know they're present. We're not aware of them. So we're not doing anything in our security program to protect from them because we just weren't aware that they existed to begin with. And that really comes into play as the business matures and evolves or goes into new markets. They're all different types of things that cause that. I mean, one thing that I've seen a lot that people don't really think about, when a company is going public, the number of attacks that they're being hit with skyrockets. And that's something that most of the time they're not aware of. And so you think about all of the business stress that's going on when a business is going through the process of going public. One of the things that's most of the time not on the radar as they're working through all of this investment planning and what this all looks like, vesting and all of those types of things, is the fact that they're fixing to get hit with a tenfold potentially increase in the number of attacks that they're getting in their network because of all of the attention that they're going to be getting in the media. So those are the types of things that you have to identify. So if I don't know that that's a risk, then I may not be setting up my security program to be able to deal with those types of risks. So hopefully that's clear and makes sense.
Perfect. So how many times, although having cyber protection and controls are in place, have you found breaches due to former insider information leaked, internal taking advantage of weakness, social engineering reasons, or what is the most common reasons? Justin, let's start with you.
Most common, I mean, that's hard to answer because it varies quite a bit. I would say that there are common attack vectors. That's kind of really, I guess, how I would look at it. But you can look those up every year on the Verizon reports that come out and everything and kind of see where things are going. We know that email is the most common vector coming into an environment. We know that there is a lot of elevation of user privileges that takes place to kind of get access to additional data. But it also depends on the industry a lot of times. It depends on the program that was in place. I mean, that's kind of the thing, right? If someone has their eye on your organization, they're trying to get in, they're going to be looking for vulnerabilities in your unique organization. So at some point, even the statistics about what generally happens doesn't apply to your business in particular. Because if I, for instance, know in general, this is how attacks happen, and so I've really beefed up my security program to address those, but I didn't know what was the highest risk for my business now because it has moved, right? I've addressed some common vulnerabilities that are there, but now for my business, the risk profile has shifted. So currently then, if I'm not aware of how those risks exist in my organization, I'm not going to be beefing up my security program now in those areas. So that's the maturing that we're talking about that Shawn was alluding to earlier. It's not a static thing, it evolves. So when I think about an organization independently, you might tell me the industry, and maybe we look up some stats. This is how it typically starts. But if you've been addressing those things, I can tell you for your organization, that's not your biggest risk. Your biggest risk may be unpatched vulnerabilities on this server, or you may be allowing vendors to come in and a particular vector that may open you up to third-party risk. So anyways, that's a non-answer, and I don't mean to give a non-answer, but it is so fluid that that's really the best you can do.
I definitely agree. That is, coming up with the numbers, unless you have all the stats from the research and the statisticians that has gone in, that would be difficult just to say that right now. But I would say a lot that you see, it deals with the end user, right? So whether it's going to be inadvertently through lack of security controls within the organization, whether they've been social engineered through a number of different ways, whether it's smishing or phishing or any number of ways to do it. A lot of those openings allow that threat vector to be exploited. So if you're not having the certain, if you don't have multiple layers of protection in place, so maybe you've done pretty okay with your email security, but something gets through. Maybe someone's on a different network. Maybe someone plugs something in. There's just one little, opening that someone's looking for, and now your endpoint security is, you cut corners there, and now you don't have that protection at that layer to come in and prevent those types of things. And now someone has found a way in. So working with organizations where you're working either side by side or next to the ones that are doing whether the white hat hacking and what have you, they're always looking for a way in, right? So they're going to find something on your network. They're going to find, especially during the pandemic and everyone started working remotely, and you've got people working in coffee shops and all of these types of things. And then even Justin mentioned the third party. So if you're going public, then, oh my gosh, I mean, third parties are coming in. How many ways are you giving out your information? I used to do, once upon a time, physical penetration testing, right? So go into buildings and, and talking to different folks, they felt really secure once you're on their floor because there's a security guard downstairs, right? But the security guard downstairs is that alarm goes off all the time on the doors. They just ignore it. So once you're through there, everyone upstairs feels secure, but it is just very easy to exploit that. So a lot of times you see a lot of things from an end user standpoint. through a number of vectors. Everything's online now, so why not try to exploit those types of things? And then sometimes there's that intentional insider threat or that disgruntled employee, but a lot of times it's just people. Some people are just trying to do their jobs and they're trying to do it easier, and they may not have the tools that they need to do it. I used to get a lot of calls in for that. Hey, funny again, back to risk assessments. I'm like, hey, do you know you have a whole bunch of employees that are forwarding things to their Google accounts? Like really sensitive data. They just send it over because they want to do work at home because they're running out of time. So that's an easy fix. Provide that type of level of security and culture within the company to allow them to either be comfortable with timelines or allow them to be able to work remotely securely. So those types of things. But yeah, so I would say a lot of things, and I don't know, Justin, if you agree that it's a lot of a user, right? Weaknesses tend to be exploited the most.
So
I want to let Shawn give a comment because he says this statement a lot of times that I think is really fitting. He says his job is to protect people from their data. So the organizations are holding all of his data, and they don't necessarily know that they have it. Sometimes I've seen situations where there was a whole bunch of PII and email accounts for a business division, and the cyber team didn't even know that they were handling PII. And so they weren't aware of the right process for how they should be putting that in the right places because no one was aware they were dealing with it. So someone like Shawn comes in and basically says, hey, you got to know those things because here are the risks that are going to come through that.
yeah, I mean it's helping organizations protect their information and protect them from their information. And people are always like, what? It's because data is the risk at the end of the day. It's like toxic waste. You've got to know what it is and you got to protect it. But to that question about the insiders, we actually have 2 active cases right now. One, a ransomware case that's active where a former privileged admin user, their account was not decommissioned and it had an outdated password and it was forgotten about. Nobody recognized it was there. And the threat actors got a hold to it, used it to, move laterally within the environment, encrypt the environment, and steal data. And so it's ongoing. We're handling this as we speak. But we have another matter where we're handling an investigation from a regulatory agency where a former executive got aligned with the head of security before he was leaving the company and got the head of security to literally give him the keys to the kingdom to take all of the customer data and go to start a competing company. And so when you have the head of security circumventing your security controls, that's a mess, right? And now they're dealing with a major investigation over this, looking back, pointing fingers at all the things they should have done differently. So what I would say is we don't see malicious insiders as frequent as we do, but when we do see them, the consequences are usually more severe because of the level of privileged access they had internally.
Garret, can you explain evidence versus functionality in identity management and identity governance?
Yeah, and I think Shawn did a good job of explaining that. Basically, grade school math. Show your work. I got that. I'll probably do it. I was at a conference the other day, and another cyber lawyer was up there, and she was stating straight out, your job, and this is where it's sometimes hard to explain to a CIO and whatever, but your job is to show your work. Your job is evidence. Cyber defense and cyber defense and compliance is being able to, as Shawn said on this, and it was great. What have you been doing the last 12 months, right? So you got breached. So you got something happen. Okay, fine. Is there evidence that you've been doing the practices that your policy states? And that's where people get in trouble. So let's relate it to identity, since that's really all I know. Identity management is functionality. That's cool. I mean, people are into it. Oh, that's the new whiz bang. It tests my nose twitch to get me authenticated. Yeah, I'm all happy, right? That's single sign-on. That's having the identity, the user be able to get the data. It's not governance. Governance, and if you look at the new NIST CSF 2.0, it has all the different domains, and then it has governance inside the circle to let people know it is the inspection and the attestation of the work. The attestation that you actually have performed this work. And that's what Shawn needs, and that's what Stacy and Justin help customers do, is they say, great, let's start with your identity. Let's throw in this UATest product. Let's make sure you can show that you are auditing. You have a practice and policy around your identities to perform the principle of least privilege. That is, remove ghost accounts, remove orphan accounts, remove excess privileges. And UATest, what it does is allows the process it automates the process and then creates the evidence that is on store in your enterprise to say, these are my practices around. This is why I am compliant. This is why I can show due care during the case of a lawsuit. So that's identity management versus identity governance.
Shawn, can you expand on your thoughts on where federal and state law will intersect and change in the future around privacy and data?
Yeah, so I personally do not think we're going to see a comprehensive federal law that addresses cybersecurity and privacy risk. I say that for other than the fact that I just can't see our Congress cooperating on something as complicated as that. But I also know that many committees within Congress have authority over a lot of these different sectors like defense, healthcare, consumers, finance and trade. And they're not going to give that power up to put it into one committee that's going to enact comprehensive federal legislation. So I don't think we're going to see a comprehensive law that just fixes all this and makes it easy for us. I think we're going to continue to see the federal level, this sectoral approach where each industry kind of is putting out its own standards. But notice they're all kind of looking at the same principles. So they may be called different things, but they're following the same principles and guidelines. And then which tend to stem from HIPAA, because that's really our most mature framework that we have as far as regulation law in the US goes. And I think we're going to continue to see the states do the beauty of federalism, which is where different states are trying different things, because ultimately we're going to find what works the best. What do we want to be our standard? And by having these states as what we call laboratories of democracy, trying different models and different techniques, we're moving towards a model of finding something that works best, hopefully. And so that's what I think we're going to continue seeing. I think they're going to look heavily to principles, frameworks, things like NIST that lay it out, because why try and reinvent the wheel when you have something that's really smart, really good people have spent a lot of time putting together. But I think that's what we're going to continue seeing. We're going to continue seeing more litigation. Right now, cases tend to favor the defendants. None are going to trial. They're getting either settled or thrown out. We're going to see that move. It always does move to favor the plaintiffs over time. I think that will continue to happen, but I think that's where we'll head with all this.
Perfect. Okay, unfortunately, we're running out of time, so I can't get to all of the questions, but let's go to contact information. So Justin, why don't you inform the audience on how you can get your customers ready for due diligence and how to avoid breaches in the first place?
I really like what James Clear of Atomic Habits says: what you measure, you improve. So I would encourage you to start measuring a lot of things, actually. And that's kind of what I do. I come in and help the organization figure out what they could measure, what they should measure, and then address those things from there. So contact information, crucial-cyber.com. You can find my contact info there, send a message through the form or my phone number. Be happy to talk with you about that.
Perfect. And Shawn, can you tell the audience how they can reach you?
Sure. Easiest way, Google Shawn Tuma or Shawn E. Tuma, so you don't get the guy with all the DUIs in Florida. But that, or you can go to my law firm website, Spencer Fane, SpencerFane.com, or my blog, Shawn E. Tuma, ShawnETuma.com. Not the guy in Florida.
Not the guy for Plano. Hi, Dallas.
Oh my goodness. And then last but not least, Stacy, can you tell the audience how they can reach you?
Yes, you can find me at www.cycam.io or on this very here LinkedIn post. So I was tagged in it. Feel free to message me on LinkedIn and let's answer some more questions or just get in touch or meet at a conference.
Perfect. And then we at UAttest can be reached at uattest.com or just write us at info@uattest.com. Thank you all for being here. We really appreciate it.
Great hour, guys.
Thank you all so much.
Thanks a lot. All the
Thank
best.
you.